May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 2 to 10, behalf of LD Sangam. Due to
to?
medical emergency, 2 to 10, Lordship.
2 to 10.
Yes, due to medical emergency, he could not attend today. So kindly list this matter on 30th of July.
30 is Thursday.
Yes.
Thursday?
I'll take it up next week.
That's
2 to 10.
What is many fixed matters on Thursday.
There is emergency.
Your Lordship, there's already a division bench judgment.
Passed by lot and
Okay.
yes, yes.
So it's a short matter, my lord.
Yes.
Your
The
Lordship.
issue is well covered.
No, it may be a short matter, but then we have no time to read the orders. Learned Counsel, Mr. A. Momi is present for the petitioners. Mr. Achungli Sanktam, Learned Government Advocate, makes a prayer on behalf of Mr. L.T.
LD
Sanktam,
Sangam, Lord.
Learned, additional AG, to list the matter after a week.
Your Lordship, if it can be listed on Thursday, why I'm saying Thursday, Your Lordship, is that the division bench of this, Your Lordship's bench, already held that the 2013 Act applies.
Hmm.
But the state is interpreting it to say that the 2013 Act does not apply.
Hmm.
We can make an attempt on Thursday, Your Lordship.
There are so many cases already listed on Thursday. Yesterday also, all Thursday. It may be.
Otherwise on Friday,
difficult.
otherwise on Friday, Your Lordship.
No, Thursday, Friday, we would not like to list because Friday is the last day this court is sitting. No, other benches also will interpret it that way because the order is already there.
Yes, Your Lordship.
Monday, 3rd,
Monday, Friday and Monday, my lord, I'm so sorry, but I have other fixed matters.
On Tuesday then, Your Lordship.
okay, 4th, then to list the matter after a week, no? With the consent of the parties,
Tuesday.
list the matter on 4th August
Thursday only.
for admission, yes.
Lordship, like,
Yes.
Lordship, if my name may kindly be reflected. I'm
Mr.
acting for respondents
Sinthiangar,
1, 2,
here's
three.
for respondent number
1, 2, and 3 in all the
1,
matters.
2, and 3. In all the matters. Okay. Yes.
May I please, Your Lordship?
Hmm.
Item number 23. Here I'm yet to receive instructions, so kindly grant me 2 weeks of time to file my affidavit.
23.
Lordship.
Learned Counsel, Mr. Petitioner,
I thought respondent 2 and 14 lang, tapi kau bilang object no most of the
respondent 2 and 3.
2 and 3.
None appears for the petitioner on the matters for Learned Governor, Mr. Achungli Sanktam, prays for listing the matter after 3 weeks, says he is yet to receive instructions. So Learned Counsel, Mr. Mo Jamir, appearing for respondent number 2 and 3, also has a similar prayer. List after 3 weeks as prayed for. Yes.
Lordship, item number 11, behalf of additional AGM Dim Song.
Hmm.
Since today he got personal difficulties,
Hmm.
so let this matter fix on next week.
Yes,
Tuesday, 4th.
petitioner is here. Any objection?
I'm for
Item 11.
I'm for item 21.
Oh, okay, Learned, none appears, no, Sinthiang, this is Sinthiangar's matter, item 11, isn't it? Learned Counsel,
Oh,
Mr.
yes,
Sinthiang is present for the petitioner. The Learned Government Advocate, Mr. Achungli Sanktam, prays for listing the matter after,
Lordship, Tuesday.
on 4/8, on behalf of.
Tuesday, my lord,
Oh.
I may have, since the other matters are already fixed on Tuesday, if another date can be taken.
No, it's
Maybe-
admission matter, that one will not take time.
I
You're
know.
available on 4th, isn't it? 4/8,
If it can be listed on 6th,
okay, 6.
same week. Lordship.
6/8 on the prayer, on the, no, on behalf of additional AG, Mr. M. Timson, list on 6/8, yes.
Deeply obliged.
My lord, in item 21, my lord, we have filed affidavit in reply today. And one IA for implement also filed. Let it come 10th of August or 11th along with,
IA for implement.
yes, ma'am. And affidavit in reply also filed.
Counsel for the petitioner, Mr. Such and such,
M. Ali.
submits that an affidavit in reply has been filed in response to the counter affidavit of the respondents. So it is also submitted that an IA has been filed praying for impletement. He therefore prays that both the matters may be listed together on 10/8. So,
And my name may be reflected in the
yes,
post
yes.
list,
Is the IA registered?
not registered,
Not
filed
yet.
today.
List on 10/8 accordingly, and the registry is also directed to reflect the name of Mr. M. Ali as counsel for the for the petition.
Obliged.
May I please, your lordship? Lordship, I beg to mention hearing item number 29. 29. My lord, the leading counsel has some personal difficulties today, so if this matter can be fixed on 10th of August, Monday.
Learned Counsel, Miss Grace Ainamki, appearing for the petitioner, on behalf of, makes a submission on behalf of the leading counsel, Mr. M. T. Longchen, who has some personal difficulties today, and prays for listing the matter on 10/8. 10/8. Learned Counsel, Miss Lauren, appearing for respondent number.
No, for appellant in the IA.
Okay, for the applicant in the IA and in IA 146, 146 of 2025 is present. Learned Counsel, Miss such and such,
Asanti Chamar.
appearing for respondent number 1 and 2. 1 and 2 is present. So
My lord, there's an interim.
the interim order passed earlier shall continue till the next date of listing. Yes,
Much.
10/8, huh?
May I please, your lordship? Lordship, I beg to mention item 122 on behalf of AIMA. Kindly grant 3 weeks time to file affidavit.
How much time?
3 weeks
3
time.
weeks. Learned Government Counsel, Ms. Bichano Kitan makes a prayer on behalf of AIMA Learned Government Advocate to list the matter after 3 weeks as she is yet to receive instructions. Stop list after 3 weeks as prayed for. None appears for the petition.
Lordship,
Yes.
hearing item 26.
Item
26.
26.
Kindly list matter after 1 week.
Who's appearing? You're appearing.
Lordship.
You don't want to take it up today. Learned Government Advocate Ms. makes a prayer for listing the matter on. When do you want it?
After a week, Lordship.
After a week. So Learned Counsel for the petitioner, Mr. Such and such, and Mr.
For item 22. For item 22, I'm present for the petition.
Oh, in item 22, okay. His name present for the petition. In item 25, who's for the petitioner?
26.
25.
26.
Item
Oh, 26. None.
Is she?
Okay, in 26, you say none appears for the petitioner, huh? And then Mr. Ali Bauzukam is present for
Respondent number 6.
respondent number 6. So, list after a week.
Lordship.
Obliged.
I oblige. Your Lordship, I beg to mention item number 27. I'm appearing on behalf of my senior TV Jamir, and with the consent, we have submitted adjournment form in advance. So if this matter be listed on 17 August.
17. List the matter on 17/8 on with the consent of the parties for hearing. Yes.
Obliged.
My please, Lordship, I beg to mention item number 17. My senior is not available today for appearance, so due to some personal difficulties, so kindly fix the matter on Tuesday, 4th August.
May I please, Lordship? My lord, I've received a communication letter from the respondent number 2.
Saying what? Who is respondent number 2?
Deputy Commissioner, my lord, by this order, I'm informed that respondent number 4 is not contesting the case, my lord.
Respondent 4 is
Yes.
not contesting.
Yes,
Who is respondent 4?
Mangmutong Ekel, Senso Mongtang. Your Lordship, may kindly see the next page, the page number 2. The letter received from the respondent number
So
4.
this is R4.
Yes, my lord.
Learned Counsel for the petitioner, Ms. Abdul Ken, makes a prayer on behalf of the leading counsel, Ms. Nitya Koza, to release the matter when?
4th August.
On 4/8/2026, as the leading counsel has some personal difficulties today. So the learned government advocate, Mr. Thibapong, has produced a copy of the letter dated 13 July 2026 from the extra assistant commissioner, office of the deputy commissioner Mokchung, indicating that the respondent number 4 is not contesting the matter. So the letter dated 13 July 2026 is kept on record and marked as list on 4/8 as briefed for.
Your Lordship, there is an
Photo.
interim order.
The interim order passed earlier shall continue till the next date of listing. Proceeding.
Much obliged. This Lordship,
Yes.
I beg to mention item number 13.
1/3.
Yes, Lordship. Lordship, if 2 weeks' time, may kindly be granted to file our affidavit in reply for on behalf of respondent number 26.
Respondent number
26
26 to file affidavit in opposition
in reply.
or reply.
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 Opposition.
Affidavit in opposition, it should be. Learned counsel for the petitioner, Mr. Mohammed Jamir is present. So learned counsel, Mr. Such and Such prays for how much time?
2 weeks' time.
3 weeks' time to file affidavit in opposition on behalf of respondent number 26. What about the other respondents? I have filed. Okay. The state respondents and the other private respondents have already filed their affidavits. So list after 3 weeks is grateful.
Most Lordship.
Lordship, if I may be allowed to mention item number 15, Lordship. This case, the state as well as the union, they have already filed their affidavit. If I may be allowed 3 weeks' time to file reply to both the affidavits, union as well as the state.
Learned counsel, Mr. Mohammed Jamir, appearing for the petition, prays for 3 weeks' time to file a reply to the affidavit in opposition of the state respondents as well as the Union of India. So please, after 3 weeks, is prayed for. The learned counsel, government advocate, Mr. Thibapong is present. Mr. Such and Such is present on behalf of the CGC. Yes.
Much obliged. Yeah, please, Your Lordship. Lordship, I beg to mention item 24 on behalf of my senior, Gauhati. Lordship, we are yet to receive instruction in this matter, so if this matter can come out of the 24.
Mention is made by Mr. Such and Such on behalf of Gauhati CGC to list the matter after
3 weeks,
3
Lordship.
weeks as he is yet to receive instructions. So learned counsel for the petitioner, Mr. Mohammed Jamir is present. Mr. Appearing. So list after 3 weeks. Yes.
Much obliged, Lordship.
Lordship, sorry for the indulgence, Lordship. I'd like to mention item number 21. Lordship, this item has been mentioned without my consent, Lordship.
21.
Yes, no consent was taken for my side, Lordship.
Actually, what happened is one IA has been filed, I'm told. And that
Lordship,
has not
we have
been
raised,
listed
we have raised our objection, Lordship. Preliminary objection. That may be heard first, Lordship.
regarding the IA.
No, Lordship. In the main writ petition, we have raised objection regarding the maintainability of the writ petition. Because without implementing the main party, Lordship, that is the cybercrime, they have come before this court. And a notice has been sent to them, Lordship, with regard to the freezing of the account. Because the account was involved in multiple cyber scam, Lordship. Crores of rupees has been transacted, Lordship. Now, without implementing the necessary party, Lordship, and the writ petition is not maintainable, Lordship. It's prematured.
No, we will say that the maintainability is kept open. We can, because we have already fixed it on 10/8, isn't it? 10/8.
Lordship, can it come on Thursday, Lordship?
10/8.
Because there's an urgency, Lordship. Because, Lordship, we have filed our affidavit where we have put on record the notice sent on the.
Learned
But-
counsel, is it convenient for you on 6th? 4th or 6th?
I'll have to come from Gauhati, so my
No,
lord,
they have the local council here, Lordship.
4th or 6th?
my lord, that's.
Sixth.
Next week, we said, my lord, 10 or 11, my lord.
No, we originally we have fixed it on 10th,
Yeah.
but since the learned council is saying there's urgency, we'll bring it to 6th, okay?
And
Instead of
Lordship,
10th, you say 6th August, yes.
at least the consent should have been taken, Lordship. Without taking the consent, they are mentioning, Lordship.
You're supposed to get the consent
Lordship,
actually of the other side. Yes,
Oblige, your Lordship.
and you reflect the name of Mr. Ed Musik as counsel for respondent three. Yes.
Oblige, your Lordship.
Lordship, I beg to mention item number 19.
Mm.
I'm appearing for respondent number 4. And I would like to pray to give 4 weeks time to file our affidavit in opposition.
Yes.
May I please, Lordship. Lordship, as per the last order dated 5/6/2026, Lordship, the respondent number 3, the Union of India, has been directed to file an affidavit as well as to obtain an instruction and file an affidavit on or before 21st of July. However, till today,
He is mentioning on behalf of respondent 4.
Lordship.
Who's appearing for the Union of India? Mr. Yangarwati is on leave.
Lordship.
This is the problem. He has submitted letter of absence from. It is not reflected here. Someone was here on behalf of Yangarwati just now.
His junior was.
Yes, when is he joining? Yangarwati?
Lordship, tomorrow.
Tomorrow. We'll give them a week's time.
Lordship.
Learned Counsel, Mr. V. Koza is present for the petitioner. Learned Counsel, Mr. Such and Such makes a mention you're mentioning on behalf of N.K. Luikam.
Yes.
Makes a mention on behalf of the leading counsel, Mr. N. Luikam, for respondent 4 to and praise for listing the matter after 4 weeks as he would like to file an affidavit in opposition. So, Learned
I am for the state.
Senior Government Advocate, Mr. Moin Chen is present for the state respondents.
I will not file. I am yet to file my count.
You will not file.
I will not file.
Okay, and submits that the state respondents will not be filing any affidavit. Stop. The learned counsel for the petitioner submits that on the last occasion, this court had directed, which order dated?
5/6/2026.
By order dated 5/6/2026, this court had directed the Union of India to file their affidavit within a week. Is it?
Lordship, before 21st
Oh,
of July.
Before 21st of
July 2026.
July 2026. Stopping, he therefore prays, and he submits that the Union of India is yet to file their affidavit. Stop. Accordingly, taking into consideration the fact that the Union of India as well as respondent number 4 are yet to file their affidavits, list the matter after 1 week. Or make it 2 weeks, after 2 weeks, yes.
Welcome.
Please, Lordship. Lordship, I beg to mention item 14, Lordship. Here I am for the private respondent number 7. I'm yet to file my affidavit in opposition, Lordship. I've taken the consent of the opposite party, Lordship.
Counsel for the petitioner, Mr. Sentiang is present. So, Learned Counsel, Mr. V. Kozal makes a prayer to allow him, how much?
2 weeks time,
2
Lordship.
weeks time to file the affidavit on behalf of respondent number
7.
7. So prayers allowed, list after 2 weeks. Yes.
Lordship,
The interim order passed earlier shall continue till the next date of listing. Yes.
Much obliged.
Lordship, in item 12,
Hmm.
I may kindly be granted 3 weeks to file my affidavit in reply.
Learned
have-
Counsel, Mr. Sentiang makes a prayer for 3 weeks time, 2 weeks time to file.
weeks, my
2
lord.
weeks to file
lord.
affidavit in reply to the affidavit in opposition of the respondents. Prayers allowed, list of the 3 weeks.
Deeply obliged. my lord.
Lordship,
Here
I'm
also
for
there's the-
respondent number 2 and 3, Lordship.
Here also interim order passed earlier shall continue till the next date of listing. Yes.
Please,
Mr. Nisuka Chishi is present for
2 and 3, Lordship.
1, 2, and 3.
Deeply obliged. my lord.
Obliged, Lordship.
For motion, item number 1.
My lord, by this application, petitioner is seeking a direction to the bank authority to defreeze his bank account, my lord. He was, my lord, operating a current bank account in the Canara Bank of my lord, Somukodima branch, my lord. My lord, suddenly on 8/11/2024, my lord, his bank account has been frozen, my lord, without any prior notice, my lord. So, my lord, at this stage, notice may be issued to the,
Notice, have you served to respondent 1 at least?
yes,
Who's appearing? You served on the
Without serve-
CGSC?
without serving, my lord, it would not be numbered, my lord.
No, you served it on the CGSC or who? For one, respondent one.
That after some time, I'll have to confirm with my junior colleague, a local council member who has served.
I called after some time.
Yes.
You
From the
accepted?
From the supplementary calls list for motion item number 30.
Hey, please, Your Lordship. The petitioner was appointed after government approval. Your Lordship. I'll just take Your Lordship through the record. Annexure A, Your Lordship. Page 15.
Yes.
The type copy is at page 16. So by this, dated 26 September 2022, the government
Where's the petitioner's name?
at serial number 5, Your Lordship.
Hmm.
The person who was promoted and the BIMS number is also clearly given. Then on the basis of this, in pursuance of this, annexure 17, Your Lordship, and annexure B, page 18 is a type copy.
Appointment order, 26 September 2022.
2022.
Yes.
For a probation of 2 years, on completion of the probation period, she shall be considered for service confirmation. Now, Your Lordship, joining report is at annexure C, page 20. This is dated 7th of October. Now, similar to the petitioner's appointment by various notifications and government approvals, which I have annexed here from annexure D1 through D.
Annexure D1.
T1 through T7, page 22 to 34. So most of these were appointed subsequent to the petitioner, except one person that is at annexure T1. All of them, same government approval order, same appointment, similar appointment orders on. The appointment orders say the same thing. Now, since her initial appointment, Your Lordship, she has not received even a single month's salary.
From 2022.
Yes, from 2022. So what happened? Annexure E, page 35, Your Lordship. This is the letter of the director, page 35. Requesting issue of temporary BIMS code in respect of the petitioner. Here the director has also clearly stated that she is serving without salary. Now, unknown subsequent to this, unknown to the petitioner, by annexure F, page 36, this is 25th September 2025, the government issued this letter. Now, by this, appointment of the following individuals that was notified by the department was not in accordance with BNAR OM number so-and-so, dated 27 September 2019, pertaining to procedure for appointment to every category of post by any department. So here, the petitioner's name is listed as serial number 6. Now, the petitioner was not even notified about this.
No notice.
No notice was given. This letter was sent. Now, the office memorandum, which is the relevant memorandum, which is referred here. If Your Lordship may turn to annexure G, page 37.
Hmm.
Paragraph 4 is the relevant. Page 37. In view of the if I may read,
Hmm.
in view of the circumstances stated above, the proposals for any new fresh appointments by any department for every category of post may be submitted to the administrative head of department for prior approval for due process of recruitment by the NBSE, Departmental Recruitment Board, and AHOD shall be responsible to verify the availability of the sanctioned post and duly authenticate each post vacancy against a unique employee code generated by the personal information management systems or the post creation order in case of new post. Any appointment order issued without following the due process and without the unique employee code from PIMS shall be considered invalid, null, and void. So they are basing this letter on paragraph 4 of this PNAR poem. The government itself verified everything and then approval was granted. Even the PIMS code was verified and accordingly administrative approval was
Was
granted.
there any recruitment process?
No recruitment process, but the government itself, in all these cases, the government itself approved our case and then we were appointed. Now, that was in the month of this order, this imbued letter was issued in the month of September, 25th September 2025.
Hmm.
Petitioner was unaware of this.
Hmm.
No notice was given. Now in 2026, 22nd January, because her salary was kept pending and she was being informed that PIMS code is yet to be generated.
Hmm.
She submitted this representation for release of her salary.
Hmm.
She was not knowing about the existence of this.
Hmm.
Then suddenly, by the impugned order, that which is at page, annexure I, page 39. The typed copy is at page 40. A very peremptory order. In pursuance to the, this is dated 20th of May 2026. In pursuance to the government letter number so and so dated 25th September 2025. List of particular of the government servant released from duty on 30/4/2026, and then my name is listed at serial number 6. Your Honor. So no salary since her initial appointment. She was being continued. Then in the month of September 2025,
Hmm.
the government decided to apply fee and dues and then directed the director to terminate our service. No notice was given. Then it continued till May and suddenly no notice, prior notice was served, was just terminated from service. I have been released from service.
Then what about the
So-
others who were also appointed after you? Were
They-
they also
they are-
appointed?
they are being
after-
paid, they are
No,
continuing.
no, were they also appointed after a due selection process?
No, same. All of us are in the same boat.
Okay. We'll issue notice at this stage.
And if your lordship may state a.
No, stay, but we'll say that
Yes.
subject to the outcome of the petition.
Your lordship.
Yes, the petitioner hearing has come before this court in the instant application, under Article 226 of the Constitution of India, praying for washing of the, where is your prayer? Praying for quashing of the impugned letter dated 25/9/2025 and the impugned order, the impugned release order, is it? Release
Yes.
order dated 25/2026.
Pass with retrospective effect, your lordship.
Passed with retrospective effect. So it is, the petitioner has also prayed for a direction to immediately release the salary of the petitioner from October 2022 up to date. And to release the petitioner's salary with interest at the rate of 9% per annum. Stop. Third learned counsel for the petitioner, Mr. Tongko Pongoner. The main grievance of the petitioner is that by a government approval letter dated 26/9/2022, administrative approval was granted for appointment of the petitioner to the post of expert weaver against an existing vacancy. and in pursuance thereof, by an order dated 26/9/2022, the petitioner was appointed as expert weaver in the Directorate of Industries and Commerce, Nagaland. Stop. However, the petitioner is yet to be paid salary from the date of her initial appointment on the ground that her PIMS code has not been generated. Stop. Meanwhile, the government, by the impugned order dated 25/9/2025, directed the termination of the service of the petitioner and 5 other employees on the ground that their appointment was not in accordance with the PNR OM dated 27th September 2019. Stop. However, other similarly situated persons are still continuing. However, persons who were also similarly appointed are still continuing in service. Being aggrieved, the petitioner is before the court. Stop. Para. Issue notice returnable in 4 weeks. So the learned senior government advocate, Ms. S. Mary, has accepted notice on behalf of the state respondents. All the respondents, yes. On behalf of all the respondents, hence no formal notice is called for. However, the learned counsel for the petitioner shall serve extra copies of the petition on the learned government advocate during the course of the day. So please, after 4 weeks, the impugned orders dated 28 July 2023 and sorry.
25.
Dated 25 July
2020.
20th May, dated 20th May 2026 and
The government letter
the
dated, the
government
impugned letter dated
letter
25
dated,
September.
21st, where is that page?
The
25th September 2025 are sought to be suspended by the learned counsel for the petitioner. Stop. However, this court is not inclined to suspend the same. The impugned orders shall remain subject to the outcome of the writ petition.
and with
Please,
regard to
after
the
4 weeks.
salary, if in the
Salary cannot be done
during pendency of the
No, we cannot say that.
until the instructions.
Please, after 4 weeks.
For motion, item number 1.
I'm sorry, my lord, it has been already served, my lord, 2 series.
Served, received. The present application under Article 226 of the Constitution of India has been filed by the petitioner, praying for a direction to defreeze, is it?
Yes, ma'am.
Defreeze the petitioner's current bank account number 120031778744 of Canara Bank, Chumukudima branch, Chumukudima, which has been kept on hold since 8/11/2024. Stop. Learned counsel for the petitioner, Mr. M. Ali. It is stated by the learned counsel for the petitioner that the said bank account of the petitioner has been blocked by the head office of the Canara Bank without issuing any notice to the petitioner and without any communication from any investigating agency. Stop. Being aggrieved, the petitioner is before this court. Stop. Para. Issue notice returnable in 4 weeks. The learned counsel, Mr. Such and Such, on behalf of Yangarwati CGC, accepts notice on behalf of the respondent number 1. Stop. The petitioner shall take steps for service on the respondents number 2, 3, 4, and 5 by speed posts as well as usual process within 3 working days from today. List after 4 weeks.
My name may be shown in possession.
Yes, the name of Mr. M. Ali may be reflected in the cause list as counsel for petition.
Highly obvious.
For admission, item number 16.
This case, respondent number 4, the
RCI is yet to file their affidavit.
Who's for?
RCI, respondent number 4.
Who's appearing for respondent for?
Your Lordship, on the last occasion, they were appealed through VC.
Hmm.
Outstation counsel, Lordship.
Outstation.
Yes.
Learned counsel for the petitioner, Mr. Mohan Jani is present. Stop. Learned senior government advocate, Mr. N. Angami, represents the respondents number 1 and 2, 1 and 2.
Yes, ma'am.
Then who else?
Kikire for respondent number
Kikire
3.
For respondent number, Kikire for respondent number 3. And what about 5 and 6? No, 5. N. Angami is for 1, 2, and 5.
Yes.
And state mission director,
No one appears on behalf of 6, despite notice.
Mr. Angami, you can appear, or
Actually,
The
Your Lordship,
Samagra
yeah,
Shiksha?
this is actually an autonomous body under the
Mm.
School Education Department. However, I feel, Your Lordship, my affidavit will cover their case, Your Lordship.
This is also a state agency only, actually, isn't
Yes,
it?
but it's an autonomous like NHM under the medical department.
okay. Okay, anyway, you say 1, 2, 5, and 6, no? N. Angami. And K. Kiri for respondent 3. Today, none appears for the respondent number 4 when the matter is called. And the affidavit in opposition on behalf of respondent number 4 is also not filed. Stop. Least after 2 weeks?
Lordship.
Least after 2 weeks.
Obliged.
Item number 18.
My lord, I am appealing for the petitioner. Oops. My lord, may I hand over a short notes of argument on behalf of the petitioner, along with judgments. My lord.
This is listed for admission hearing.
My lord, yes, my lord.
If it's ready for hearing, we can list it in the hearing column.
My lord, it's ready for hearing. I'm also ready to submit, my lord. This is a short point of maintainability which has been raised by the learned counsel for the state, my lord, in their opposition, that the petitioner does not have locus standi and the closure report has attained finality. My lord, if I may place my case.
Okay.
My lord, I am an insurance company, Tata AIA, registered under the Insurance Regulatory and Development Authority. My lord, I have preferred this writ petition on the basis of a claim that has been lodged by the wife of the victim deceased in an accidental case, my lord. My lord, the purported accident took place on 18 January 2025.
18 January
2025.
25.
Well, let me kindly note that a policy for a total sum assured of 2 crores under accidental death benefit rider of 1 crore was taken out by the victim on 4th June 2024. Well, thereafter, barely
Who's appearing for respondent 4 and 5?
well, private respondents, the wife and the brother of the victim, and one of them is the complainant, de facto complainant. Well, on the last occasion, probably learned counsel for the state stated that their appearance is not required for the maintainability point to be decided and heard.
Otherwise, notice
Well,
is complete.
Notice was already issued.
Notice complete on 4 and
Notice
5.
was issued. I don't know whether it is completed. It was taken by the state.
Let us see, let us see.
But on the last occasion, despite notice, their presence was not required. That is the reason.
Notice issued by speed post written. Why not required? Because if your petition is allowed, they will be affected, isn't it?
Of course, you.
Yes.
My lord, but it is against the state. My lord,
Your ladyship, in fact, they have no local standard. That's why we have raised maintainability, so.
my lord, that, let me satisfy
No,
on that
leadership,
point.
That is a different issue, maintainability, but regarding notice on 4 and 5,
Notice on 4 and 5, I don't know, if it's not
My
completed,
lord,
then it
is
has to
their-
be.
It is their complaint. If there is a further investigation as prayed for in the writ petition, how are they going to be prejudiced?
no, because if they have been served notice, but they are not appearing, at least this court has a duty to appoint legal aid counsel on their
That's right.
behalf.
Well,
Yes. Last tracking report indicates item impact. There is no further updates on this information. Last update office notice 21/5, where it says last tracking report indicates item backed, but there is no further update. Postal receipts and tracking report place at A and B. The notice is also not complete.
my lord, at least 2 days since I've traveled from outstation, my lord, if the point of maintainability may be decided and hence it can be kept for final hearing upon notice to respondent number 4 and 5.
No, we'll decide everything together and keep the issue of maintainability open. Upon going through the office note dated 21/5/2026, it is seen that the service on the respondents 4 and 5 is yet to be completed. So it appears that according to the tracking report, it appears that the item was bagged at BAGGED, bagged at Dimapur on 1/4/2026. Stop. However, there is no further update on the same. Stop. Learned counsel for the petitioner, Mr. Such and such is present. Stop. And learned counsel praised that the issue of maintainability may be heard today. So learned senior government advocate, Ms. S. Mary, is also present for the state respondents. Stop. However, considering the fact that the notice on respondent and 4 and 5 is yet to be completed, list the matter on when?
But if it can be kept in the first week of September, my lord.
First week September. On 7th September 2026, on which date the matter, the issue of maintainability will be heard and decided. Stop. As far as the
My lord, just the maintainability or the entire petition? Because my lord, it is.
we can see whole writ petition on which date an effort will be made to dispose of the writ petition. Okay, and the issue of maintainability is also kept open. So then regarding the notice on respondent 4 and 5, the registry is directed to track the speed post consignment again and keep the report in the records and keep the report in the tracking report in the records.
If it pleases your lordship, my
Yes.
lord, may we serve privately and file an affidavit of service on the next date?
That can also be done. Yes, that can also be done.
Dusty.
You delete that portion about the tracking. You say the petitioner is also allowed to take steps by Dusty on the respondent 4 and 5 and to file a compliance affidavit before the next date. List on 7-9.
For admission, item number 20.
May I please, Lordship?
Yes,
Lordship, this is a short matter. Lordship, this is for admission.
matters are short.
All matters are short.
For you, all matters are short. For that part, it is not so short. Anyway.
This is for admission hearing, Your Lordship.
Mm.
The pleadings are complete. All the parties are represented.
Mm.
Your Lordship, the matter relates to NIT
Mm.
and award of contract
Mm.
for mitigation and restoration of road from NH 29
Mm.
to Forest Colony via Josoma village.
Mm.
Now,
NH 29 to Forest Colony.
via Josoma village. The contract is for mitigation and restoration of road. For mitigation, I'll take Your Lordship to the NIT. Now, petitioner is challenging the NIT in question on the ground that the impugned NIT was not published in any newspaper as required under the NPWD code and also the Nagaland Public Works and Accounts Rules 2012, the rules of 2012 for short, Your Lordship. Now, may I first take Your Lordship to the code and also the rules. May I first take Your Lordship to the code, Nagaland Public Works Department Code, Your Lordship. Then refresh, may I read out? Why it is code. This book, as its title indicates, contain mainly rules to be followed by the officer. These are rules which are to be followed by the officer of the NPWD. The book has been made comprehensive so that so that the Nagaland Public Works Department officer may be, as far as possible, find at one place the basic rules required to be observed for execution of work, the basic rules. So this code is, Your Lordship, in short, is the compilation of basic rules which are required to be observed by the officers for execution of work. Now, may I take Your Lordship to page clause 291. Clause 291.
Calling and acceptance of tenders.
Changing, calling and acceptance of it. May I read out?
Yes.
Sealed tenders should invariably, means constantly in every case, be invited in the most open and public manner possible by advertisement in the Government Gazette or the press or by public notice. Tenders should have free access to the contract department. Notice should state such and such, but I am on publication, Your Lordship. Next is the rules of 2012. Lordship has got it? Rules of 2012? Yes. Now, this rule has been published in the Nagaland Extraordinary Gazette in November 6, 2012, Your Lordship. Page 2, notification, short title. So, this has been published in the Gazette. May I take Your Lordship to chapter 4, page 20. Chapter 4 deals with tender agreement and work order.
Page 20.
page 20.
Hmm.
Lordship has got it.
Hmm.
Now, in tender, the last clause 13, Your Lordship, I'll just the relevant part. I'm relying on this. Lordship has got it.
Yes.
Tender notice endorsed to all deputy commissioner of the district, secretary of the department, all major heads of development department notice board, in addition to newspaper publication. Now, Your Lordship may see this this NPWD code. This is published in 1970. In the preface, it is there.
70. Yes.
70. And this public works and accounts rules 2012 has come. So at the time when this was published, the code, this was not there. So this is not incorporated. So this should be read along with the code. Now, Your Lordship, the fact that the impugned NIT in question was not published is admitted by the respondent authority in reply to the information sought under RTI. So the reply, may I take Your Lordship to my petition at page 27.
Page
Page
27.
27. Lordship has got it? Page 27, Lordship has got it. Column 2, number 3. This is the information sought. List of newspaper online portals where the tender was published. Now, fourth line from the bottom, that is the reply in the right-hand side. Hence, to avoid such like the NIT were published and notified in the office notice board. In other words, it was only displayed in the notice board, not published in the newspaper. And then copy of the NIT was also furnished to the petitioner, Your Lordship. So the respondent authority has admits that it was not published in the newspaper. And my case is that non-publication of the impugned NIT, Your Lordship, being contrary to the rules and procedures prescribed for award of contract, the impugned NIT is not valid. And therefore, the impugned NIT and also the work order issued pursuant thereto, Lordship, in favor of the private respondent number 5 are liable to be quashed and set aside. May I take Your Lordship to my prayer? Page 16.
And the petitioner is a registered contractor.
Lordship. Those are not disputed.
Where is it?
Page 16.
Page 16. Yes.
No doubt the respondents, both the respondents, state respondents, and also as well as the private respondent, they have questioned my locus, but I reserve that for reply, Your Lordship. Page 16. Page 16, Your Lordship. Yeah. Quash and set aside the impugned NIT, such and such, dated such and such, issued by Chief Engineer PWD, Your Lordship. That is the impugned NIT. 17. B. That is the work order issued in favor of respondent number 5. And my prayer, C, Your Lordship, is to direct the state respondent to issue fresh tender for the remaining unfinished work of mitigation and restoration of road from National Highway 29 to Forest Colony by Ajasuma Village by publishing in the newspaper, Your Lordship. Your Lordship, this is my case. Now this
Was
honorable,
there a interim order?
Yes, your lordship. I'm taking your lordship to that. Interim order is 5/5/2026. May I take your lordship to the interim order? Lordship has got it?
Yes.
May I read out? This order dated 5/5/2026, para 3. Referring to the RTI reply of the Office of the CEPWD, it is stated that in the RTI reply dated such and such, the concerned PIO has admitted that tender was published only in the office notice board. Accordingly, by filing this writ petition under article such and such, the petitioner has assailed the tender number such and such issued by the respondent number 3 insofar as remaining unfinished work is concerned, and for setting aside the said tender, and has further prayed for issuing a fresh tender for remaining unfinished work by publishing the same in the newspaper. 4. It is submitted that in the aspect of similar illegality of posting NIT in notice board without publication in NIT newspaper, this court in the case of SPN Enterprise, I'll be taking your lordship to that, had set aside the tender process for publication of the same only in the notice board and not in the newspaper. In other words, this is already covered. 5. Opposing the plea of the interim relief, learned senior government advocate Mr. N. Nangami has submitted the work order in the case that was issued on such and such, and the period of completion of work is 6 months, and therefore it is submitted that by now a substantial work may have been done by the respondent number 5 contractor. It is also submitted that as rainy season would be setting in soon, it is in the public interest to complete the work before the onset of monsoon. It is also submitted that even if the petitioner parties split, there is only a question of chance as to whether the petitioner would be settled with the contract. Now, para 10. On consideration of the interim period met in, it is noticed that this court in the case of SPN Enterprise has interfered with such tender process where notice was posted, put up only in the notice board and not published in the newspaper, had interfered with the concerned tender. Therefore, the court is of the considered opinion that in cases where the tender are quietly published in office notice board and by avoiding public notice through newspaper, therefore, in order to maintain transparency in the tendering process undertaken by the government, this is the fit case for staying forthwith all balance work that may be pending pursuant to the short NIT number such and such and consequent work order that may have been issued pursuant to the said tender notice. The petitioner shall also serve certified copies of the order of such and such to make this order effective on respondent number such and such, who in receipt of the same shall pass consequential order for implementation of the direction content herein before. So interim orders, pass your lordship. Now, in my respectful submission, your lordship, the issue involved in the present case is squarely covered by the order passed by this honorable court in HPN Enterprise, which is writ petition 63
2023 JLR.
2019.
It's here.
It's there, your lordship?
Yes.
Yes. Since this is my case, may I be permitted to read? Para 2. The petitioner is challenging the issuance of the work order dated such and such to the respondent number 7 by the chief engineer for construction of brick wall such and such. 3. The respondent in the reply have submitted a notice inviting tender for the above contract work on the ground that it was issued without notice inviting tender being issued by the state respondent. 3. The respondent in the reply has submitted a notice inviting tender for the above contract work with an estimated cost of such and such had been issued on such and such by the Office of the Chief Engineer, PWD, Government of Nagaland. However, the said note NIT dated such and such was not published in any newspaper but was posted in the notice board in the office of the CE. Same case as this version. Now, para 9. The issue involved. The question, lordship has got it, para 9. That is the issue involved. The question to be decided is whether there was any illegality, arbitrariness in posting the NIT in the notice board of the office of the CE and not publishing the same in a newspaper. This is this issue involved in this petition. Now, para 18. These are the observation and finding of this Honorable High Court. Para 18, Your Lordship has got it. In the case of such and such, this court had to decide whether the award of a contract to the respondent number 5 without any NIT being published by the state respondent in any newspaper was liable to be set aside. The NIT had been posted in a notice board. Even in that case, Para 19, this court in the above sessions held that the award of the contract without publishing the NIT in a notice in a newspaper was in violation of 2012 rules and the CWD code. This court held at para 29 to 32 as follows. I have already found that in terms of clause 291 of the PWD code, I have taken your lordship to that clause. The tender notice is to be published in Government Gazette or press or by public notice. Even item 13 under this Sahabat tender had tender agreement and work order in chapter 4 of the rules of 2012, which I've taken your lordship to, further requires that the tender notice are to be endorsed to all deputy commissioners, secretaries of the department, all major head of development department and notice board. In addition, such tender notice are to be sent to the newspapers for publication. 30. Moreover, the CPW code, amongst other things, also require whenever any value of this is the central, I'm not relying on this. 31. In fact, these codes and rules were honored more in violation than in observance, like in the present case. A bare perusal of the NIT in question makes such a position very clear. Therefore, there cannot be any escape from the conclusion that in settling the contract in question in favor of private respondent, in this case, respondent number 5, the department violated all the rules and procedure vis-a-vis settlement of contract. The learned additional AG, however, contended in the case in hand, the NIT was published in the notice board, and according to him, such publication is a publication in contempt. As contemplated in clause 291 of the PW code, such publication also satisfies the requirement of the rules 2012. This also is the stand taken here. Unfortunately, such contention hardly meets the specification met in the aforesaid codes and rules, and as such, I have no hesitation in rejecting such all arguments. 20. This court in the above such and such allowed the writ petition and set aside the work order issued in favor of respondent number 5. However, since in that case, 70% of the work has already been completed, this court directed the state respondent to measure the work already done and to issue a fresh NIT in respect of the remaining works and to bring the same to conclusion in accordance with the relevant rules and procedure. Para 23. In the present case, the NIT was notified only in the notice board as has been done in the case of such and such. Also, 40% of the work has allegedly been done by the respondent number 7, while 70% of the work has been done in the case that is the earlier case. The fact situation is similar in the present case and the above case of such and such, including this case, Your Lordship. Keeping in mind the facts that the contract was awarded without any publication in the NIT in any newspaper or in the mass media, which is against public interest and the interest of public exchequer, the issuance of the work order is found to be arbitrary. 4. Accordingly, the work order dated such and such issued by the respondent number such is hereby set aside. No further action should be taken in person to the NIT, and then consequent orders were also passed to issue fresh NIT, Your Lordship, for the remaining portion of the work. Just to cut short, Your Lordship, the facts are similar. The case of the petitioner is squarely covered by the two judgment passed by two different coordinate bench of this Honorable High Court, Your Lordship. So accordingly, my respectful submission, Your Lordship.
And here also, how much work has been done
Here,
according to them?
no. The percentage, or they've given a let the state respondent
Okay.
make the reply, Your Lordship. So my only submission that petition has a prima facie case, Your Lordship.
Okay.
So this petition will be allowed by granting the relief as spread for Your Lordship. And
Yes.
I conclude, Your Lordship, but I may be permitted to reply.
Yes, yes, of course. Yes, Mr. Angami.
May I
Like,
please, ma'am?
similar order can be passed.
Lordship, allow me to contest the with the best possibility I can. Your
Okay.
Lordship, allow me to contest the case, Your Lordship.
I don't know how much you can improve on that, but anyway, let's.
I will try my best to convince this honorable court, my lord. Lordship, kindly allow me to take my lordship to page 33. This is the work order, my lord. Page 33 of the writ petition, my lord.
Hmm.
Yes, Your Lordship, subject. Subject, Your Lordship. I may be allowed to read this, my lord. Just a subject. Work order for the work mitigations and restorations of work from NH29 to Forest Colony via Zotsoma Village, NH29 Zotsoma Bypass Road, Kohima under SASCI 2025 to 2026, Your Lordship. So the road is the Zotsoma NH29 Zotsoma Bypass Road, Your Lordship. Now this road, Your Lordship, I do not give any detailed explanation to this particular road because my lord, I'm 100% sure my lord must have traversed to this road.
Every day.
Yes.
Almost every day.
Yes, Your Lordship. And more particularly, when there is a natural calamity on the main highway, this road becomes the lifeline, Your Lordship.
Okay.
Yes. And Your Lordship, the lifeline not only to the citizens of the district of Kohima, but also to the citizens of the neighboring state, such as Manipur, Your Lordship. There was a case where an emergency situation was there as yearly basis, Your Lordship. Very unfortunately, we have a major landslide where the national highway is completely cut off. And therefore, this road is the alternative road where people from the citizens of the Kohima, as well as from the neighboring state Manipur, has to travel to the district of Dimapur and further to other states of the country, Your Lordship. And therefore, there was an emergency situations to finish up the work or to maintain the work before the monsoon season starts, my lord. This is the reason why, Your Lordship, we have floated the NIT in the public notice board of the office, Your Lordship. Without floating it in the NIT in the public notice, the work order was not issued, my lord. It was published. Your Lordship I may be allowed to bring my lordship to page 9, para 7 of the writ petition, my lord.
Page 9.
Page 9.
Yes.
Here, Your Lordship, para 7. Your Lordship has the petitioner has quote the rule 291 of the NPWD code. The rule 291, Your Lordship. And what does the rule 291 says? Allow me to read this, my lord. It says, may I read it, my lord? Sealed tender should invariably be invited in the most open and public manner possible by advertisement in the government gazette or the press or by public notice. Or in the government gazette or the press or by public notice, Your Lordship. What office notice board, Your Lordship? This is a public notice board. It is not just meant for the staff or the officers of the concerned department. It is a place where all the important notifications or orders or any changes made by the department are pasted there for the public convenience and for the public to see. And therefore, this NIT also was pasted there. And that is also amounting to a public notice, Your Lordship, which is in accordance with Rule 291 of the NPWD Code, my Lord.
Now the petitioner was not vigilant enough to come and observe and see the public notice. That cannot be termed as a fault of the department, Your Lordship. When other contractors
Yes.
when other contractors could manage and come and see at the notice board that the NIT has been floated there and submit their bidder, Your Lordship, submit their bids for the NIT. If the petitioner have not seen that, he was not vigilant enough, Your Lordship. NIT was floated in the notice board, Your Lordship, and there was a bidder. From among the 3 bidders that the department has received, my lord, the private respondent has quoted the lowest rate, and therefore the work was awarded, Your Lordship. The work was awarded basing on the NIT floated on the notice board, the work order, Your Lordship, 26th of February 2026 was issued. And therefore, the notice, the NIT that was pasted on the notice board cannot be said that it is not a public notice as per Rule 291 of the MPWD Code, my lord. The second point, Your Lordship, I wanted to make my submission on is I want my lordship to kindly come to page 29 of the writ petition, my lord. Page 29, my lord. This is the NIT, NIT dated 13th of February 2026, my lord.
Yes.
Now, Your Lordship, this NIT was floated with certain criteria. Your Lordship will find that criteria at page 30. Terms and conditions, there are as many as 10. 10 terms and conditions. We are concerned with conditions, terms and conditions number 4, my lord. I may be kindly, we are permitted to read these, my lord. Terms and conditions number 4. The criteria for issue of tender documents. Contractors who have successfully completed one similar nature of work during the last 5 years, counting not less than 30% of the tender amount. So it is not every contractor, even if we float in the newspapers, as has been submitted by my another senior friend here. Even if we float it also, the contractors who fulfill these particular conditions are the only one who can apply or who can bid for the work, my lord. Now, Your Lordship, nowhere in the writ petition they have stated that they fulfill this criteria. Nowhere. They have not even made a whisper of it, that they fulfill this criteria, Your Lordship. Your Lordship, in our affidavit in opposition, we have raised this issue. At para 10 of my affidavit in opposition, Your Lordship, we have raised this issue, saying that there is a criteria mentioned in the NIT. So even if the NIT is floated, Now, even if NIT is floated in the newspapers as desired by the petitioner here, Your Lordship, still then, do they fulfill this criteria or not, Your Lordship? And if they do not fulfill this criteria, Your Lordship, then they don't have the locus standi. That is the issue we have raised, Your Lordship. In our affidavit in position, they have not given their reply.
Then,
Your Lordship,
yes.
by not filing the reply, the law is well settled. Your Lordship is well aware that when something that has been raised, if it has not been refuted or denied specifically, Your Lordship, it is deemed to have been admitted, Your Lordship. They have not denied this part. That means, Your Lordship, they do not fulfill this criteria, Your Lordship. So in such circumstances, Your Lordship, even if NIT is floated, where is the locus standi, Your Lordship? Now to challenge the actions of the department when they do not fulfill that criteria, when they cannot participate in the NIT, in the so-called NIT, which they are now asking to float it, Your Lordship. The second question, the second issue is, Your Lordship, the second issue, Your Lordship. The second issue is, yes, if this honorable court cancels the work orders, the NIT, and asks the department to issue a fresh NIT, if the petitioner does not have the criteria to participate again in the fresh NIT, so directed by this honorable court to be floated in the newspapers, Your Lordship, what right of the petitioner has been violated, Your Lordship, by not floating in NIT? Because even if the NIT is again refloated, if the petitioner cannot participate or if the petitioner does not fulfill the criteria to participate in the fresh NIT, what right of the petitioner has been violated, Your Lordship? They cannot explain that. There is no explanation to the issue that we raised in our affidavit. They have not given their reply. They have not replied to those issues that we have raised, Your Lordship. And therefore, the question is, what right has been violated, Your Lordship? What right of the petitioner has been violated? They'll have to first show that they have a locus standi to challenge the actions of the respondent. When they don't have a locus standi, Your Lordship, to challenge the actions of the respondent, what right of a person approaching this court has been violated if they cannot show that, Your Lordship?
Yes, next.
Your Lordship, the balance of convenience, Your Lordship, on the issue of balance of convenience, I just wanted to conclude my submission by saying this, my Lord. For an instance, admitting that, Your Lordship, the petitioner have got their criteria, everything to participate, and they were not given a fair chance to participate in NIT. What loss has been caused to them, Your Lordship? Maybe a few sum of money. But if the road, Your Lordship, if the road, God forbid, but unfortunately, if the road, the main road, there is a natural calamities, and if this lifeline road cannot also be used, then there is a very likelihood of a loss of life, Your Lordship. So the balance, Your Lordship, is tilted more towards the respondent than the petitioner. And this is also one reason why, Your Lordship, the prayer of the petitioner should not be allowed. Also, Your Lordship, on the issue of the local standard, Your Lordship, this petition deserves to be dismissed, Your Lordship. I'm deeply obliged, madam.
Please, Your Lordship, for the respondent number 5. Now, I adopt the submissions made by my learned friend
Yes.
for the state respondents, but I would just like to supplement with some of my own submissions. Now, insofar as the maintainability of the petition is concerned, I have also raised an objection in that regard regarding the locus, to the effect that despite the filing of the counter affidavit by the respondent 5 as well as the state respondents, the petitioner has not controverted or clarified and stated that he has completed such and such work as has been stated in serial number 4 of the NIT. Now, therefore, it is admitted that the petitioner has no locus and cannot maintain this petition. Now, in view of that, in view of the admitted fact, now the question, I would like to summarize the question as to whether the dishonorable court can exercise its discretion to examine the matter and whether the reliefs can be granted. Now, in that regard, allow me to just make two short.
Yes, government affidavit, which para was it regarding the locus?
Para 10, my lord. Your Lordship will find that at page.
Yes, yes, yes. And in the affidavit of respondent 5?
Yes, I've raised it as a maintainability issue in the introductory portion. From paragraph 2 to 10. Yes. Now, if your Lordship may kindly come to the NPWT code as has been extracted by the petitioner in his writ petition at paragraph 6, page 8 of the petition.
Yes.
Now, the relevant portion as has been quoted in this petition, it says tender notice clause 13. Tender notice endorsed to all deputy commissioners of the districts, secretary of the department, all major heads of development departments, notice board in addition to newspaper publication. I'm emphasizing on the phrase in addition. And secondly, in the next page, the clause 291 relied upon by the petitioner. Allow me to just read the first paragraph. The heading says calling an acceptance of tenders. 291. Sealed tenders should invariably be invited in the most open and public manner possible by advertisement in the government gazette or the press or by public notice. Emphasis on the word or. Now, therefore, in view of the fact that it is not disputed that the notice has been published. Now, therefore, it cannot be described as though the mere publication of the notice is illegal or arbitrary. At best, it can only be described as a procedural aberration insofar as the issuance of the NIT is concerned, because it does not violate the NPWT code. In view of the words in addition to the newspaper publication as well as the word or. And therefore, the public notice has been issued. And it is not the case of the petitioner that it was not issued. And in view of the fact that the comparative table as enclosed in the states.
But reading along with rules of 2012,
yes.
it says in addition to newspaper publication.
Yes, in addition to newspaper publication. But I'm emphasizing that notice board publication by itself does not mean that such publication amounts to an illegality. It has been published. It says in addition to. So merely because it was not published in a newspaper, it does not mean that publication in a notice board itself by itself constitutes an illegality. And in that view, publication of notice board of the NIT, the notice board, is only a procedural aberration. Yes, there was a procedural aberration, but it has been published. So it cannot be said that the state respondents in publishing the notice has violated the NPWT code. Now, in view of the fact that the petitioner has admitted, as he has not produced any rejoinder affidavit to clarify that he has the eligibility criteria to participate in the tender process, such an interpretation being the interpretation of the tendering issuing authority, the locus the petitioner cannot maintain this petition. In that view, the question is whether this honorable court can exercise its discretion to test the NIT issue, the process of NIT. Now, in my humble submission, the exercise to be done by this court, in the absence of a petitioner who has no locus to maintain the petition, would only be a roving or an academic exercise. It would amount to the roving or an academic exercise. And if at all a relief was to be granted, at the instance of a petitioner who has no locus, such a relief would be misplaced. Now, therefore, it is my humble submission that the petition deserves to be dismissed solely on the ground of maintainability. Now, in support of my submissions, allow me to just rely on place some few citations for my own benefit. I am relying on another point of fact is, as already pointed out by my learned friend. Now the work has started. As per my instructions, around 30% of the work has been completed. And in that view of the matter, this honorable court's consideration may also keep that view in mind because of the work having been commenced. Now, the first authority that I'm relying on is 1999, 1 SCC 492, on the point of locus only. Now, I'm relying on this authority for the proposition that if at all the relief sought as has been sought by the petitioner is to be granted, at the instance of the petitioner who has no locus, then such a relief would be misplaced. I'm relying on paragraph 27.
Paragraph 27.
Paragraph 27, page 506 of the report. Lordship has it?
Yes.
In the present case, however, the relaxation was permissible under the terms of the tender. The relaxation which the board has granted to MS so-and-so is on valid principles looking at the expertise of the tender and his past experience, although it does not exactly tally with the prescribed criteria. What is more relevant, MS so-and-so, who have challenged the tender, this award of tender themselves do not fulfill the requisite criteria. They do not possess the prescribed experience qualification. Therefore, any judicial relief at the instance of a party which or who does not fulfill the requisite criteria seems to be misplaced. Now, this was passed in view of the fact that the High Court has allowed the petition of the challenger. On appeal before the Supreme Court has laid down this proposition that granting a relief at the instance of somebody who is not qualified to challenge to participate in tender would be misplaced. Now, the second authority, 2023, 19 SSC 1. Now, although I do not dispute the fact that this honorable court can exercise its discretion. Now, the jurisprudence insofar as the tender matters are concerned, it has been laid down. It has narrowed down since 1979 to the present day. It has narrowed down insofar as the interference of the constitutional courts are concerned. So in this authority at page 50, sorry, at paragraph 50, paragraph 50, page 18. This court, being the guardian of fundamental rights, is duty-bound to interfere when there is arbitrariness, irrationality, malafidis, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising their powers of judicial review in contractual or commercial matters. Now further down, I'm also relying on paragraph 51. Here also in this matter, it pertains to the exercise of jurisdiction, to the exercise of discretion by the Honorable High Court. It is not in dispute that the first and foremost requirement of the tender was the prescribed operating range of the single-decker buses, which would operate for around an average of 200 kilometers in a single charge in actual conditions, with 80% SOC without any interruption. Then, materials on record would indicate that Tata Motors, in its bid, deviated from this requirement and had informed BEST, that is the tendering authority, that it could carry the operating range in the standard test conditions, which was not in accordance with the tender conditions. This is the operative portion I'm relying on. The High Court has rightly observed in its impugned judgment that the bid of Tata Motors failed to comply with the said clause. Tata Motors deviated from the material and the essential terms of the tender. It may not be out of place to state at this stage that it is only Tata Motors who deviated from the condition referred to above. However, we are of the view that the High Court, having once declared Tata Motors as non-responsive and having stood disqualified from the tender process, should not have entered into the fray of investigating into the decision of BEST to declare AV as the eligible bidder. We are saying so because the High Court was not exercising its writ jurisdiction in public interest, same as the case here. Filed by a party trying to assert its own rights, as held by this court in Roanoke International, which I just relied on, that grant of judicial relief at the instance of a party which does not fulfill the requisite criteria is something which could be termed as misplaced. Now, therefore, in this case also, the petitioner has not shown his eligibility to participate in the bid, despite the asking for a public advertisement. And therefore, in the absence of having any eligibility criteria to participate in the tender, relief, if at all any relief was to be granted, it would be misplaced. Now, the third authority, again on locus, 2022 SEC Online SC 1334. No.
Airport Authority.
No,
Airport Authority.
yes, Airport Authority of India, paragraph 26. For the proposition that once this honorable court, if this honorable court comes to the conclusion that the petitioner is no locus, then at that threshold only, the petition deserves to be dismissed. 26. At the outset, it is required to be noted that respondent number 1, claiming to be a non-profit organization carrying out research, advisory, and advocacy in the field of civil aviation, had filed a writ petition challenging the tender conditions in the respective RFPs. It is required to be noted that none of the GHS who participated in the tender process and/or would have participated in the tender process have challenged the tender conditions. It is required to be noted that the writ petition before the High Court was not in the nature of public interest litigation. In that view of the matter, it is not appreciable how respondent number 1, or the original writ petition, being an NGO, would have any locus standi to maintain the writ petition challenging the tender conditions in the respective RFPs. Respondent number 1 cannot be said to be an aggrieved party. Therefore, in the present case, the High Court has erred in entertaining the writ petition at the instance of respondent number 1, challenging the eligibility criteria tender conditions mentioned in the respective RFPs. In fact, the High Court ought to have dismissed the writ petition on the ground of locus standi of respondent number 1, original writ petitioner, to maintain the writ petition. Now, I would also like to rely on some of the authorities passed by this honorable court as well. Now, the first one is 2025 SEC Online Gauhati 5096. This has been passed by the division bench, headed by His Lordship, the Chief Justice.
This is also on locus.
Yes, also on locus, and also not on, no, this is not on locus. This is on the exercise of the discretionary power of the writ court. Once it finds that there has been a procedural aberration or procedural illegality, and also in a context of the contract work having been commenced. Now, in this case, the writ court found that yes, there was a procedural illegality, but having noticed that the works have commenced, it has declined to interfere because of the jurisprudence that has been narrowing down insofar as the interference of in tender matters are concerned. So I'm relying on paragraph starting from paragraph 13. Paragraph 13. True it is that it would have been more fairer if such disclosure were made in the NIT, or it would have been declared upfront before the evaluation, and all the bidders would have been notified regarding such evaluation method. But this is the operative portion I'm relying on. But not doing so, not publishing one of the conditions, in our estimation, falls in the realm of procedural illegality. Now, this is the defining on a division bench, procedural illegality, which does not automatically warrant setting aside of the contract. 14. Needless to state that judicial review in tender matters is limited, particularly after the commencement of the work. The Supreme Court in many cases has cautioned that the court ought not to act as an appellate authority over the administrative decisions, and that even if some procedural aberration is found, the court must weigh the larger public interest before granting relief. 15. The present project work is under a centrally funded scheme, as is the case in this instant petition, which, if not executed within the timeline, would lead to lapsing of the central fund, thereby saddling the state with the responsibility of completing the unfinished task. The question before this court is whether such decision ought to be upturned at this stage when the work has already been started by the respondent number 4. The Supreme Court has already cautioned in many cases that semi-completed or substantially progressed contracts should not be interfered with, even if some irregularities are found, unless malafide or fraud are established. Now, at this instant, allow me to submit that in the petition, there is no specific pleading insofar as malafide is concerned. Now, of course, some inference are being made, but it has not been pleaded, nor has it been established except for the mere bold allegations. Now, paragraph 19. While we cannot approve undisclosed deviation from the tender terms, but we do reckon that disproportionate relief is required to be avoided. Disproportionate relief is required to be avoided. Setting aside the contract at this stage would cause irreversible harm to the public interest, far outweighing the procedural grievance of the appellant. In our considered view, the appropriate course to be adopted would be to decline interference while recording disapproval of the tendering authority's conduct, in not uploading the minutes of the meeting on its website, or notifying the bidders and issuing prospective corrective directions. Now, the last authority, also passed by a single bench of this Honorable Court in WPC 96 of 2022. Allow me to read some of the paragraphs. Now, in this matter also, the objection raised by the respondents was on the locus. And the High Court was pleased to dismiss the petition for having on the ground that the petitioner had no locus standi to maintain the petition, as well as on the merits of the petition after discussing certain authorities. Now, the paragraphs I'm relying on are from paragraph 9.
9. Yes. On the issue of maintenance.
On the issue of maintainability of the petition at the instance of the present petitioner, raised on behalf of the respondents, a brief deliberation on this aspect at first appears necessary. From the bidding document, it has emerged that the participant bidder had to submit its documents with regard to valid GST registration. The respondent number 6 in his affidavit in the position has asserted that though the petitioner firm was enlisted as a class 1 government contractor with registration number so and so, but it did not have a valid GST registration. In the instant petition, the petitioner quoted its GST registration number as so and so. The respondent number 6 has asserted that when it checked the official website of the Commissionerate Dimapur Division Range, Kohima Range, with regard to GST registration of the petitioner, the website showed that the status of GST IN so and so is cancelled suo motu with effect from such and such. This in his affidavit in reply to the affidavit in the position filed by the respondent number 6. In his said affidavit in reply filed on so and so, the petitioner has merely stated that upon expiry of the GST registration, application was made for renewal of the GST registration, and the same was pending before the competent authority. So this was the live issue in this petition. Now the court further goes on to say at 9.1, there is no dispute with the legal proposition that the rights under Article 226 of the Constitution of India can be enforced only by an aggrieved person, except in the case where the writ prayed for is for habeas corpus or quo warranto. One further exception is in relation to public interest litigation. Ordinarily, the existence of the legal right of the petitioner which is alleged to have violated is the foundation for exercising the jurisdiction under 226 of the Constitution. By a long line of decisions, three categories of persons vis-a-vis the locus standi have been identified, who are: one, a person aggrieved; two, a stranger; and three, a busybody or a meddlesome interloper. If a person approaching the court satisfies that the impugned action is likely to adversely affect his right, which had genesis in a statutory or constitutional provision, such a person falls in the category of aggrieved person, and the writ petition filed by such person cannot be rejected. In the case 9.2, in the case in hand, the date of the NIT was so-and-so, and the last date of submission of bids was so-and-so. It has thus emerged that the petitioner did not have valid GST registration either on the date of the publication of the NIT or on the last date of submission of bids fixed by the NIT. The NIT had laid down the eligibility and qualification required on the part of the bidders to participate in the tender process and to be awarded with the contract work, with the further stipulation that a bidder suffering from ineligibility and lacking qualification would not be permitted to submit bid. The petitioner firm has not placed any document or any other tangible material to show that it had eligibility and qualification laid down in the NIT to participate in the tender process undertaken for the contract work. Thus, the petitioner has also not been able to demonstrate before the court that he had the eligibility and qualification to participate in the impugned tender process, save and except pleading that had the NIT been widely circulated as prescribed by law, he would have also participated in the tender process undertaken for the contract work. Faced with such lack of details, the petitioner has not been able to persuade this court to record a finding that he falls in the category of aggrieved person whose any kind of legal right had been violated. And therefore, this case squarely covers the case of the petitioner. Now, the reliance placed on SPN enterprise case. That case does not assist the petitioners. In that case, the question of locus was not a live issue in that matter. In the reliance, in that case also, the discussion was not as to whether the in that case further, the authority relied upon in Yingqiao Lota. In that case, the contract was awarded to a contractor who was not even eligible to carry out the contract work. But by then, 70% of the work was completed. And therefore, the court found it fit that he should be compensated for what has been undertaken. But those were the cases on his facts. In this case, in this instant petition, those are not the issues. The issue is whether the petitioner has the locus, has the eligibility criteria to participate in the tender, if at all, even if the NIT was floated. The answer is in the negative. Now, therefore, that the foundational threshold has not been crossed by the petitioner. In that view of the matter, I would submit that this honorable court, if this honorable court was to exercise its jurisdiction to examine the matters or the merits of the case, then and subsequently a relief is to be granted, then in my humble submission, such a relief would be misplaced as has been laid down by the Honorable Supreme Court. Now, finally, allow me to just rely on two more paragraphs. Now, this Honorable Court also went on to rely on the paragraph 15.6. 15.6. Now, this is how the jurisprudence, insofar as the interference of courts in tender matters, is being narrowed down by NG Projects Limited. 15.6. In NG Projects Limited, Supra, the Honorable Supreme Court of India has taken note of the provision contained in newly inserted Section 41 in the Specific Relief Act 1963, as amended by the Central Act 18 of 2018, and has made the following observations. Since the construction of road is an infrastructure project, and keeping in view the intent of the legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provisions should be kept in view even by the writ court while exercising its jurisdiction under 226 of the Constitution of India. Unfortunately, in this case, at the instance of a contractor who does not even have the eligible criteria, the contract word has been stayed. Paragraph 23 of the NG reports case. Even if the court finds that there is total arbitrariness or that the tender has been granted in a mala fide manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The injunction or interference in the tender leads to additional costs on the state and is also against public interest. Now, this would echo the submission made by the state respondents, and I completely adopt these submissions. Now, paragraph 17 also may please your lordship. Paragraph 17. This is also what I've submitted in my affidavit in opposition. It is not the case of the petitioner that the contract who had been awarded the contract works lacks the eligibility and qualification to execute the contract work. It is also not the case of the petitioner that the contract work has been awarded at a price higher than the estimated cost. It is also not its case that the estimated cost and arrived at rupees so and so is in violation of any prescribed norms. It was the respondent number 6 out of the 3 participant bidders who had quoted the lowest bid value at par with the estimated cost and emerged as a successful bidder to whom the contract work was awarded. There was no allegation to the effect that there was any collusiveness amongst the participant bidders in the tender process. Decision in Yingqiao Lotha was rendered by taking into consideration clause 291 NPW code while interfering with the work allotted to a contractor who did not have requisite qualification to apply for the work. On a perusal, it is noticed that the earlier decisions in Roanoke International, which I've just quoted, so and so, which have dealt with the aspect of public interest vis-a-vis the expediency in interfering with an ongoing contract work in the midway, were either not placed for consideration before this honorable court, nor considered in Yingqiao Lotha. This was how the single bench came to its conclusion. And finally, at paragraph 21, in light of the above discussion, this petition was also dismissed. Now, therefore, my humble submission is that even though non-publication of an NIT, it may be a justiciable issue in a proper case. I do not dispute that, but at the instance of this petitioner, who has no eligibility criteria to participate in this, insofar as this contract matter is concerned, and being an FP, I would only submit that this petition deserves to be dismissed at the threshold on the ground of locus standi. The petitioner is not an aggrieved person. This petition has been filed only for his own personal interest, not in public interest. Therefore, if this court was to injunct or interdict with the contract work which is already ongoing, it would affect the public interest. I'm deeply obliged.
May I please, Your Lordship?
Yes.
Lordship, my reply may take a little more time than my but my reply will cover both, Your Lordship. It will be a joint reply.
Okay.
And before I reply to the respondent, Your Lordship, now may I reply to Your Lordship's query regarding the percentage of work first? Regarding the percentage of work done.
They said 30%.
Yeah, that is what I have said, Your Lordship. Now, may I take Your Lordship to para 15 of my petition, page 13.
In fact, this vertex is against my order. So that has been that has been upheld.
15, Your Lordship.
Yes.
Para 15, page 13. My read petition.
Page 13.
Yes.
Yes.
Yes. It is stated that though the impugned work order has been issued on 26/2/2026, and as per the terms and conditions mentioned in the impugned work order, the work is to be completed within 6 months, however, on the date such and such, except for profile correction for about half a kilometer, rough drainage excavation and construction of retaining wall for a few meters, no other major work has been undertaken by the respondent number 5 pursuant to the issuance of work order, that is even after a period about 2 months. Now, state respondent of it is silent, but in the affidavit filed by the private respondent at para 23, Lordship, I will not take your Lordship to that. It is stated that these are matter of official record. However, the state respondent is completely silent as regards the percentage of work executed, Your Lordship. Now, the private respondent has made a verbal submission that 30% work is completed, Your Lordship. But in the affidavit of opposition, it's totally silent. It said it is only stated that it is a matter of official record. Now, that was on Your Lordship's query. Now, coming to the reply to the respondent, Your Lordship, may not be in sequence, Your Lordship, but just point-wise. the learned counsel for the state respondent has started the submission by saying that the road in question is a lifeline. Now, and then it is not new. Then what prevented the state respondent to do it in such a hierarchy? The work of mitigation restoration the NIT could have been floated much earlier, but not. And then relying on the NPWD code, you're saying that the public notice displaying the NIT in notice board, it complies with the NPWD code. But as I've said, Your Lordship, NPWD code and Lordship has also currently said it has to be read with Rules 2012, which says in addition to newspaper publication, Your Lordship. Now, in my respectful submission, when a thing's rule procedure provides how a thing should be done, it should be done in that manner or not at all. Doing in any other procedure is forbidden. That is what the Honorable Appeals Court has held in Hukum Sin's case, Your Lordship.
No, that is not disputed at all.
Yes.
But now you have to address the court on the locus.
I'll be coming to
Because,
that. I'll be coming to that.
Because
Your
if
Lordship.
we are to
Because
decide the locus, then only if it's found that you have the locus, then only we go into the merit.
yes, Your Lordship, that is my second. So this, so that was the second point raised. I am going point wise, Your Lordship. Now, both the state as well as the private respondent has questioned the locus of the petitioner on the ground that the petitioner is not eligible to para 18 of law. As per the terms and conditions of the NIT,
Yes.
Your Lordship. Now, therefore, before considering the locus of the petitioner, in my respectful submission, the first issue which needs to be considered by this Honorable Court is whether the terms and conditions contained in an invalid NIT can be enforced by the respondent against the petitioner, and the question is locus. Your Lordship. And as the respondents are relying on the terms and conditions of an invalid NIT, Your Lordship, why I say invalid? Because the NIT will become valid only once it is published. And petitioner is questioning the validity and legality of the NIT. But since the respondents, they are relying on the terms and conditions of an invalid NIT, which is known as in law, Your Lordship, it is for the respondent to satisfy this Honorable Court by placing at least one authority. Yes, to satisfy this Honorable Court that the terms and conditions of an invalid NIT, which is known as in law, can be enforced by the respondent against the petitioner to question his locus. In fact, in my respectful submission, if while considering the locus, if this Honorable Court take into consideration the terms and conditions of an invalid NIT, that will validate the NIT. And that issue was not decided in Naga Builders case. That was not the issue. Though the last case law which has been referred, Naga Builders 96 of 2023, 22, where the petition was dismissed on locus. That issue, whether the terms and conditions of an invalid NIT, which is not legally enforceable, that terms and condition can be enforced against the petitioner by the respondent and to say that, no, you are not eligible as per the terms and condition of the NIT. When petitioner is questioning the validity and legality of the NIT itself. Now, the terms and condition can be looked into by this honorable court, your lordship, in my respectful submission, subject to your lordship satisfaction, your lordship, even only if and when this honorable court arrives at a finding that NIT, though it is not published in local newspaper, is valid. Then the terms and condition of that NIT can be examined. And this issue was not considered. This issue, in fact, was not framed. This issue was not determined in Naga Builders case, your lordship. So in my respectful submission, the NIT being not in conformity with NPW code and also the rules of 2012, your lordship,
So the condition 4 cannot be.
NIT is not
applied.
valid. When NIT is not valid, the condition, terms and condition, the NIT cannot be looked into, considered, subject to your lordship satisfaction. That NIT, terms and condition of an invalid NIT cannot be enforced by the respondent against the petitioner and question the locus. Therefore, questioning the locus of the petitioner by the respondent by relying on the terms and condition of an NIT which is known as in law is not legally sustainable. Now, the learned state respondent has also laid emphasis on balance of convenience, your lordship. Whether the balance of convenience is in favor of the petitioner or in favor of the respondent, your lordship. Now, before looking into the balance of convenience, the first thing you should, in my respectful submission, your lordship needs to see is whether petitioner has a prima facie case. Balance of convenience will come at the time of considering the entry, but not while deciding the marriage, your lordship. And in my respectful submission, the NIT being violative of NPWD code and also the rules of 2012, and also by relying on the earlier two judgments passed by two court in bench of this honorable court, your lordship, the petitioner has a prima facie case because it is squarely covered by the judgment, your lordship. Now, the learned counsel for the respondent number 5 has relied on several judgments. But in my respectful submission, your lordship, subject to correction, in none of the case relied upon, your lordship, relates to non-publication of NIT.
Facts, of course, very different.
Those matters relate to award of contract or challenge to NIT, which is floated by someone who is not eligible as per the NIT, which is published. Publication of NIT, your lordship, is to be as per the procedure laid down. For instance, in the present case, NPWD code and Nagaland Public Rules and Account Law 2012. That is publication. So far as award of contract is concerned, your lordship, that calls for judicial review of the decision-making process, which even in NG project, your lordship, court has limitation. When expert tender committee, they examine, they scrutinize the tender, the bid, and then award the contract. Technical bid, financial bid. There, your lordship, the power of judicial review is limited. And all those cases relied upon are not regarding the challenge met regard to publication of NIT. Those are awards of contract. That is the second stage, Your Worship. And Your Worship, the ratio of a decision has to be understood in the fact situation of that particular case, Your Worship. This is 2015-11 SAC 12, page 12 on precedent, para 30 and 31. Para 30 and 31. Lordship has got it. It is well settled that the ratio of any decision must be understood in the background of the facts of that case. The following words of such and such. Each case depends on its own facts. And a close similarity between one case and another is not enough, because even a single significant details may alter the entire aspect. I'll be coming to Nagaland builders. In deciding such case, one should avoid temptation to decide cases by matching the color of one case against the color of another. To decide, therefore, on which side of the line a case falls, its broad resemblance to another case is not at all decisive. 31. Subpara. Court should not place reliance on decision without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed, Your Lordship. Now, I'm relying on this person when in my respectful submission, going by as per the principle of law laid down by Honorable Apex Court, Your Lordship, the authority relied upon by the respondent number 4, Your Lordship, are not applicable to this issue, Your Lordship. Now, lastly, Your Lordship, may I take Your Lordship to Nagaland builders, Naga builders, the case, Your Lordship. I'm sorry, Your Lordship, I've taken out, I've uploaded from our website, but the learned counsel for the respondent number 5, he has submitted SCC online. This is writ petition 96 of 2022.
Yes.
Lordship has got it. Naga builders and suppliers. I don't know whether paragraph will tally. Times. Para 10, Your Lordship. Petitioners only contention in the NIT.
Yes.
Does it tally, Your
Yes,
Lordship?
yes.
Okay.
Now, petitioners only contention
Contention, yeah.
that the
NIT was not published in one district. In the writ petition, I am on this. In the writ petition, the petitioner has not referred to any provision which was violated by the state respondent authorities in publishing the NIT. Lordship has got it. It was only at the time of hearing the learned counsel for the petitioner has raised the plea that the process undertaken with regard to NIT was in violation of clause 291 of the NPWD code, and for such contention he heavily relied on this. Now, may I take Your Lordship to my writ petition, para 6 and 7. Page 8, para 6. Lordship has got it?
Yes.
In para 6, I have quoted Rule 2012. In para 7, I have quoted clause 291. And another point which have been taken note by the single judge is this same paragraph, Your Lordship, but next page it will be on registration of respondent number 5. somewhere in the middle,
Para 10.1.
para 10, that registration or resolution number 5 with the null contract was lapsed since before NIT was, he was not eligible. On registration, something, another ground is taken. But your lordship, this thing is that in that writ petition, your lordship, in Naga Builders, that no specific plea was taken regarding violation of the code and PWD code, your lordship, and also the rules of 2012, your lordship. But I have made my pleading, in my writ petition, I have categorically made a mention that non-publication of the NIT is in violation of the NPWD code and also the rules of 2012, your lordship. Now, may I take your lordship to para 6.4. I don't know whether. Here,
The same judgment.
yes, 6.4. Several case laws have been relied.
Such and such
Yes, yes.
completed, huh?
Now, the case laws the authority relied upon from somewhere in the middle, Ronak International. Lordship has got it in
Yes,
italic, Ronak International. This is one case relied upon. Now, in Ronak International, your lordship, the NIT was published and contract was awarded, your lordship. This is not about non-publication of NIT. The dispute was purely between two tenders. The unsuccessful tenders have questioned the decision-making process of the tendering authority, your lordship. That is in Ronak International. Next case is Tejas, your lordship, construction. Even here also NIT was floated. And the challenge was the manner in which the tender was evaluated and contract was awarded. Next case is Chhattisgarh, your lordship. Here also the matter relates to floating of tender and retender, not about non-publication of tender, NIT. An NG project. In NG project, your lordship, here also NIT was invited. The challenge was a decision of the tender evaluation committee in awarding the contract. Now, coming to 6.5. Here, Air India is. Here also, your lordship, petitioner, I challenge the decision-making process. It is not about non-publication of NIT. The last case is Nagar Nigam. The challenge was the advertisement here, floated by Nagar Nigam for running a slaughterhouse. In all the cases referred here in Naga Builders, and also referred by the Learned Counsel for Response number 5, your lordship, the issue was not about non-publication of NIT, except Naga Builders, your lordship. The challenge was the decision-making process of the tendering authority in awarding the contract. But the fact remains, your lordship, that
Yes.
in Naga Builders also, the challenge was
the
non-publication
non-publication.
of NIT. And the judgment which I have relied on, and that passed by earlier 2 separate court in the bench, that also relates to non-publication of NIT, your lordship. Now, though facts are different, the challenge made a difference, your lordship. In earlier, the code and then the rules were relied upon, but in Naga Builders, that was not. But there appears to be some conflict, contradiction, your lordship. Now,
But in SPN, there is no mention about the locus.
The
That
locus.
issue was not there.
And even in Naga builders, the issue on locus, whether the terms and condition of an unpublished NIT can be taken into consideration while determining the locus of the petitioner. That issue was not there, Your Lordship. Now, so even assuming that there's a conflict, Your Lordship, I've given list of books, 2014-16 SSC, 623. Para 17 and 19. 17, 18, 19, but I will be reading only, I'll take Your Lordship to just 17. Rule of precedent and per inquiry, Your Lordship. Now 17 says Constitutional Bench of Union of India Raghuvar Singh. Then para 18 also, the ratio of Raghuvar Singh was applied in Chandra Prakash versus State of UP. And para 19. I'll read only the relevant portion, Your Lordship. Fourth line from the bottom.
On per incurium.
19.
This is on per incurium.
Per inquiry.
Yes.
May I read out?
Yes.
It is often encountered in high courts that two or more mutually irreconcilable decisions of the Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of per inquiry.
Where are you reading from? Para 19.
Para 19, the fourth line from the bottom. Lordship has got it. It is often encountered.
Okay, yes. It is often encountered.
In high courts that two or more mutually irreconcilable decisions of the Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of per. In my respectful submission, Your Lordship, the same principle should also apply when it comes to the differences between the judgment passed by two coordinate bench, Your Lordship. In fact, the issue in this case is squarely covered by the issue in SPN. The question to be decided, that is para 9 in SPN. The question to be decided is whether there was any illegality, arbitrariness in posting the NIT in the notice board of the office of the chief engineer and not publishing the same in the newspaper. So this is the same issue is also involved in this case, Your Lordship.
Okay.
And therefore, in my respectful submission, this honorable court may be pleased to allow the writ petition by questioning and setting aside the impugned NIT and also the work order issued pursuant thereto, Your Lordship, and direct the respondent to call for the fresh NIT for the remaining works in question. Now here, Your Lordship, there's just last regarding compensation under specific relief act has been also mentioned, Your Lordship, and those will come only if my bid has been illegally rejected. Then yes, and then in such case, compensation they can always claim, Your Lordship. But this is a case where no bid has been submitted. NIT has not been published, Your Lordship. The issue of compensation, paying compensation relief under specific relief act will come only when the bid is illegally rejected. But this is not a case of illegal rejection of bid. This non-publication of NIT, the validity and legality thereof. Much obliged.
May I be permitted to just take 2 minutes? Sorry, but two
Some
points.
clarification.
Yes, 2 points on
What
that.
happened?
Now, on the question of maintainability, the submission advanced goes on a premise that it presumes that it's invalid. The petitioner is asking the court to declare the NIT invalid, in fact. Now, in order for that court to do the examination, of course, the locus has to be examined first. Now, in one authority, of course, I do not have it in my possession at the moment, but if your lordship may kindly note it down. 2003, 7 SCC 410. Now, I'm relying on paragraph 6. May I just
This is on what point?
on determining the question of maintainability first, when this kind of issue arises. Of course, my learned senior friend will be very much aware of this judgment. Should I read? I'm relying on paragraph 6
Okay,
that
paragraph 6.
question of maintainability has to be decided first. Now, secondly, on the point of illegality, now
That is one of the cases
Yes,
where Justice S.K. Samang was there.
now on the point of illegality, now the submission advanced by the petitioners tries to distinguish that there are types or flavors or stages of illegality. Now he tries to distinguish the authorities by saying that those were matters where the NIT was floated and then the illegality arose at the stage when the evaluation was made. Now, the law doesn't operate in a vacuum. Now, therefore, illegality means illegality. Arbitrary means arbitrary. Therefore, at any stage, if a court finds that it's illegal, that means
No,
illegal.
I've taken note of all that. We will
Yes.
consider.
Very much. I'm deeply obliged.
Head Learned Counsel for the petitioner, Mr. T. Jamil, E.B. Jamil. So also Head Learned Senior Government Advocate, Mr. N. Angami, as well as Mr. N. L. Iradu for the respondent number 5. Hearing is concluded, order reserved.
Much obliged.
It's done. We still have 10 minutes. But we cannot start, I think. Any other case? Any other cases left?
Yes.
Any other matters left? Yes. We will continue it. Okay, 2 then.
31 is for orders.
Orders.
Item number 31. Certainly.
Achha. What is this? I.
The IA is for implementation of respondent number 8.
In COP or in WPC?
WPC.
In the WPC. For implementation of Deputy Commissioner Chumukdima. Any
Yes.
objection?
I'll accept notice, my lord.
No
No
objection.
objection, no objection.
Okay. The instant I has been preferred by the petitioner in WPC 114 of 2025, praying for implementation of the Deputy Commissioner Chumukdima as respondent number 8 in the connected writ petition stated above. Stop. Para. Heard counsel for the petitioner, Mr. Mo Jamil. The instant application has been filed by the applicant stating that the main writ petition civil number 114 of 2025 has been filed by the applicant seeking appropriate relief pertaining to payment of rent with interest and payment of land compensation in respect of the land occupied by the Assam Rifles. Stop. By order dated 21/7/2026, the learned government advocate appearing on behalf of respondents 5, 6, and 7 had placed a letter before this court issued by the respondent number 7, wherein it has been stated that the land occupied by the Assam Rifles Training Center falls within the jurisdiction of Chumukudima district and not within Dimapur district. Stop. In view of such submission, in view of the letter written by the, who wrote the letter? In view of the
DC
such
Dimapur.
letter dated 21/7, in view of the letter written by the Deputy Commissioner Dimapur produced by the learned government advocate, learned counsel for petitioner submits that it has become necessary to implead the Deputy Commissioner Chumukudima district as a necessary party in WPC Civil 114 of 2025. Hence the present application. So, in view of the pleadings made in the application herein, comma, the prayer is allowed. So the petitioner is allowed to implead the the Deputy Commissioner Chumukodima District as respondent number 8 in WPC 114 of 2025. So the learned counsel for the petitioner shall file the appropriate amended cause title in the writ petition. So the learned government advocate, Mr. Tibapong, submits that he will accept notice on behalf of the newly impleted respondent number 8. So the learned counsel for the petitioners shall supply extra copy of the petition on the learned government advocate for doing the needful. So the application stands allowed.
Much obliged.
Item number 28, my lord.
Mhm.
I won't take time.
No, no, no. I think that. Still two more.
Just for one meter only.
28 is also there, no? Yes. 28 and 25. 25, you're appearing, you're ready?
Yes.
Then in that case, item 28 may not reach, we may not be able to take up 28. At 2, yeah, today, at 2, 25 at 2, okay. This is regarding compensation.
compensation. The union, they have occupied or lent for construction of
Is
railways.
it denying or?
They are of the contention that have already released an amount of 1.57 lakh.
They're saying that they've already
Yes,
released.
yes, yes. So when the matter was taken up in the month of October last year, this Honorable Court has given an instruction, direction to the state respondents to bring on record whether there is any record to show that any compensation was paid to the petitioner at any relevant point of time. So my learned friend, state council has already finished those records before this local court.
So some amount has been paid? Or
Yes.
nothing has been paid?
My lord, as per the record, it says that only the damage compensation was paid.
So now you are claiming as per the 2013 Act.
13 Act.
Then it will be covered, isn't it, by the
Yes.
recent judgment?
Yes, my lord.
Yes, yes,
If they are not denying.
yes.
If they are. Yes, learned counsel.
My lord, I have an objection, my lord, because here the matter has already been last to last. Here we have already paid the compensation, my lord, to the
No,
petitioner.
only the damages. Only the
No, my
damages.
lord, both the amount has been paid. Both the amount has been paid, my lord. In the affidavit in reply, my lord, we have in the affidavit which we have filed, we have clearly stated that
The 2000 Act has been calculated as per the 2013 Act.
no, it cannot be, my lord, because the land acquisition process has already been concluded long back, my lord. Now, after 28 years,
Oh, 20.
After 28 years, my lord, now they have come up before the court and saying that, my lord, they should be paid as per the new act, and they are raising the objection that they have not been paid, my lord, land acquisition compensation.
28
No,
years.
Yes, I agree, Lordship, I agree.
Then in that case, 2013 Act will not apply.
Yes,
1988, my lord, the project was handed over, 1988. Now, my lord, after 28 years, my lord, they are coming before this court, my lord, and claiming compensation firstly under the new act, my lord, which is not permissible. Secondly, my lord, a dispute as to what payment has been received and what has not been received is also, my lord, after 28 years, such plea cannot be raised, my lord, because we have categorically, my lord, made the submission that in addition to the compensation for the crop, the assessed amount of 1,58,000 that was already paid, my lord, and only after that payment the land was transferred to the railways. My lord, it's a serious question of disputed question of facts, and law has arisen, my lord, in this writ petition, which cannot be adjudicated, my lord, in exercise of power under 226, my lord. And earlier observations, my lord, will see the previous orders. The Honorable Court has already indicated, my lord, that this petition has been filed after a long delay of 28 years.
So delay is also there, plus disputed question of facts, according to you.
Disputed question of facts is also there, my lord. Because we are saying we have paid, but the state government, they are saying that it is not paid.
Take over and that
Yes, my lord.
act will apply.
We have categorically stated in the affidavit, which is reflected from the annexure 1 of the writ petition also.
My lord, as per the affidavit filed by the state, in the record, it says that only the damage compensation has been paid. That is the only.
So government is also saying only damage compensation was paid.
No, that is a disputed question of fact, my lord, because it is not the government, my lord. It is we have paid it to the party, my lord.
No, but then the acquisition process is being done by the government. That is done by the government.
Your Lordship, there was no proceeding at all.
Not by the Union of India.
No proceeding at all, Lordship. Because the Act of 1965, supposing if assuming that 13 does not apply, 65 has to be, all the procedure has to be complied with. So there's no award. In fact, Section 3, Section 4 has to be complied first. And no notice has been issued to the landowner, to the petitioner, expressing the intention that the state intends to acquire the land. And there should be an award. There's no award at all. In a similar case, I'll be relying on two judgments of the Honorable Apex Court.
In that case, it will require a detailed hearing
My lord.
next week, okay? Next the matter. When? 6th.
Lord,
Convenient.
can be next week, after 6th, my lord, because I will be out of station, my lord.
11th. 11th.
My lord, 11.
11/8. 11/8, 2026. Yes. I was under the impression that it would be a covered case, but it is seems to be some disputes.
Yes, the railways are discussing.
Maybe
Molo, court is over.
this matter on 11/8.